Welcome, ladies and gentlemen, to the third morning of the Legal Era Conference. I would like to thank the organizers of this conference at the outset. Akriti Raizada and her team always do a terrific job of organizing these events and put in an amazing effort. Thanks again to the organizers for getting all of this together. It is a Saturday morning, and this is the second panel of speakers. So with the help of all the coffee we have drunk this morning to get rid of the effects of Friday night partying, let's stir things up a bit. We have a fabulous panel of speakers, each a well-known name and with significant experience in competition law practice. First, join me in welcoming Kala Anandaraja, Head of Competition and Antitrust Trade at Raja & Tan. Second, please join me in welcoming Purnima Sampath. She is the Senior Vice President and Chief Legal Officer at Tata Digital. Then please welcome Jinsi. She is the Director, FTI Consulting. And I must say, she is the economist on this panel. She has extensive experience in competition law policy and regulatory economics and impact evaluation. It's important to have Jinsi here because of the economic underpinnings of competition law, which makes it all the more fascinating as a subject area of practice. And finally, we have a senior advocate who I'm very personally fond of. He is one of the most outstanding competition lawyers and arguing counsels today, a man who never loses his cool in the most stressful situations. Clients need senior counsels like him when confronted with claims based on bizarre theories of harm. And this frequently happens in cases in India. So let's start. I'd like to give Kala 5 to 7 minutes to talk about a little bit about Singapore competition law and how she perceives the developments under the Competition Amendment Act.
Okay, so Singapore competition law. Firstly, very good morning to everybody, and fantastic to have such a big audience on a Saturday morning. I'm impressed that we can do conferences on Saturday morning. We're not going to get this in Singapore. So thank you. Secondly, I didn't realize I was going to go first. So anyway, Singapore competition law. We are very much based on the EC approach, so the European competition law approach, which is very much driven by principles rather than rules-based as such. And as a common law lawyer as well, I like principle-based law because let me start off by saying this. If you have a rule-based law, we're all lawyers, or most of us are lawyers, and we're trained to work around that. We're always trained to find ways and means to make something work for business. And that's the best thing about the legal training we get, right? Always thinking out of the box, or increasingly throwing the damn box out, pardon the language, and seeing how we can work things around. So for that reason, I like the fact that we have a sort of principle-based approach. Now, competition law in Singapore is coming to about 20 years, but in force for about 18 years. So it is fairly mature. As I talk about Singapore, I just want to mention competition law in Southeast Asia as well. Southeast Asia is 10 countries, soon to be 11 with Timor-Leste, if that ever comes to be. And all of the 10 countries have competition law now, including Laos, but not yet enforced. Competition law is at different levels of enforcement. If you look at countries like Malaysia, Philippines, Indonesia, these are countries where it's enforced in a big way. So if you do have businesses there, please take note. They are primarily principle-based laws as well. Now, as I mentioned all of those, let me sort of drill down to what I think Anand would like me to get to, which is potentially something equivalent to the Digital Markets Act, which was introduced in Europe recently. Now, the whole idea of the DMA, Digital Markets Act, is really to try and introduce rules-based principles into competition law generally for certain types of businesses. Now, that's not entirely unusual. You've had them in traditional industries like electricity, gas. You've had them with telecommunications, media. So it's not entirely new. And yet to have something like the DMA come in for competition law, in my mind as a Singapore competition lawyer, I think is being somewhat myopic. And one of the key reasons I say that is because innovation happens so quickly and things are always evolving. So if you're coming up with rules to try and say that companies watch yourself and do by 1 to 10 so that you do not kill your competitors potentially or stifle competitors coming up into the market, or looking at it from a consumer perspective and making sure consumers have a fair choice in the market, those rules are going to change very quickly. The boundaries are going to evolve so quickly. Parameters will just keep moving. And hence, in my mind, whilst designating potentially gatekeepers may seem to work in the short term, I don't think it's going to work in the long term. I'm avoiding talking about the Competition Amendment Act because there's so many experts in the room specifically on that. And there's a lot more I can say, but let me just make one additional point. Now, if you look at the principle-based approach that I talk about, and if you look at it from a consumer perspective, many of the competition laws talk about unfair competition, either specifically within the Act or in the guidelines that are issued. Consumer protection laws also talk about unfair competition. They reference unfair practices. They reference takedown laws if we're talking about inappropriate content and so on. Now, I mention all of these because these are contained within various other pieces of legislation or within competition law, and arguably it is sufficient to go with that. So in short, what I'm saying is it's sufficient to have ex post rather than ex ante. And I'll leave you with this. I love to provoke. Everything I say here doesn't mean that I mean it. I just love to provoke. So with that, I'm going to pass it back to Anand.
Thanks, Kala. It's amazing how the European Union was able to more successfully export its antitrust principles as compared to the US. I wonder why. Because most of the countries there, and we've touched on this in the previous panel, between civil law jurisdictions and common law jurisdictions. Most of the countries in the EU are all civil law. In fact, the one lone common law country has exited. So it's amazing how civil law principles of antitrust have been exported across the world, except the US, including into common law countries. I come next to Purnima. Purnima, would you like to talk about a few amendments and what you think of them?
Sure. It takes an Anand to bring together a lovely cohort on a Saturday morning, so thank you. Thank you for that. A quick disclaimer and caveat, I should start with that. I am a senior executive in the Tata Group, but the views I express are purely mine and do not reflect those of my organization.
Well noted.
All right. I think in the last year, India has seen a plethora of legislations and drafts and bills. It's raining legislations. Many are from a consumer angle with a view to protect consumers, probably rightly so. Several are from a trader angle. How do I protect traders? Some legislations are actually from a company angle. How do I enable companies and Indian conglomerates to grow? And how do I have balances and checks and balances? The fourth bucket is how does the government work with enforcement agencies and regulators to ensure they can smoothly do their jobs? So I think these are the four lenses through which I've seen legislations. We've seen in the e-commerce space there's a lot going on. Specifically in competition, we've had a plethora of cases in the last 4 years, 5 years, many, many cases. Several touch upon digital platforms, several touch upon data aspects, limitations on sharing of data. There are broad themes that have come up. Eventually, in December 2022, there was a detailed parliamentary committee report. And based on that, we've had there have been some legislations. Specifically on the Competition Amendment Act, I know I'm sitting in the cohort of lawyers and you've all read the legislation, so let me just pick one or two areas that may be more relevant or may strike a chord with some of you. There's been a lot of talk on the definition of global turnover and penalties. Penalties makes people sit up only because it's a percentage, just like I think the GDPR set the trend, and as Anand pointed out, everybody seems to be taking its cue from the EU, to a lesser extent the UK. But when penalties are so high, it does put companies on the defense. We take greater care to draft our agreements. We make sure exclusivity agreements are handled very delicately. The penalty is a big issue. Companies are going to have to take terms of insurance, so to speak. 2, settlements and commitments. I was thrilled actually to see a dedicated section on this. And I think a couple of days ago, earlier this week, there was a draft set of regulations circulated. This to me is a win-win from all the 4 lengths that I mentioned. From a consumer angle, it allows, when there is adverse effect, when a company does something which is, anti-competitive, consumers are more often than not hurt the most. I think what the settlement and commitment regulations do, it allows companies to fix. It allows them to fix rather than spend, the next 5 years in protracted litigation. From a CCI angle, I think once the investigation is completed, when companies settle, it does make things easier for them rather than again spend hours on end in litigation and settlement. There were a couple of issues I felt that were not addressed. For instance, cartels. Cartels are kept outside of settlements. And the CCI spends an inordinate amount of time on cartels. And the crux of, there are vertical arrangements, yes, but the crux of many anti-competitive matters that come to the CCI involve cartels. So I'm not entirely certain what the thought process was. I'm sure there's good reason, but cartels are kept out of it. Another aspect that concerns me is the submissions made to the CCI while pursuing a settlement they're not confidential, which means those submissions by the company could be used against a company. I think this could be revisited, given that the overall objective is to encourage conglomerates and enterprises to settle. So these were the few odd concerns that I did have. But overall, I was thrilled to see so many positive steps in the legislative space.
Thanks, Purnima. I think I can take a stab at your cartel issue. Cartels are deemed to be so sordid, so terrible, so absolutely despicable that they are not deemed to fall within any sense of reasonable settlement. You can't really deal with them. Now, that's the perception, and that's sort of inherited from the European Union also, in a sense, because it's also the way they have defined cartels under this law. According to me, a cartel is anything between competitors that restricts the freedom of action. Now, how broadly you can deal with that, even vertical arrangements in the EU are somehow deemed to be cartels. Because they are vertical, it involves the restriction of the freedom of action. But here, a cartel is only between competitors. So if you go down the path that, and this is why I say, when we too blindly accept what the European Union is doing, and you've got to be somewhat wary of the Bundeskartellamt, because those guys are as principle-based and rule-based as can be, it becomes dangerous what you take from there. If cartels, as in the EU, cover both horizontal and vertical arrangements, and you say, and really there, what you're really worried about is price cartels, because vertical arrangements tend to get exempted all the time under 1013. And you have block exemptions for vertical arrangements. Here, you have blindly looked at them and you say cartels are not going to be subject to settlements. Okay, fine. Well, that's, I think, the perception. That's the reasoning. Coming to Jinsi, what do you feel about the amendments?
Thanks, Anand. Good morning, everyone. It's a pleasure to be here, especially representing economists and what their thoughts are on the Competition Amendment Act. I know I'm in a room filled with all the great legal minds, so I will avoid talking about anything legal. And if I make a mistake and do speak about anything legal which is incorrect, please forgive me. I personally was very excited to see the Competition Amendment Bill finally convert into an act. It's something that was being discussed from the CRC report. There were various versions of the draft which came. There are various aspects of it which I think are critical. Personally and probably selfishly, the one change which I'm most interested with is how Section 35 has been amended to now allow experts in other fields like economics to actually provide their opinion on matters that are ongoing. When I started my career in competition economics in India, I used to work with global firms, and we had experts in the US, in the EU, who were so closely involved in discussing all aspects of a case and providing their inputs, their opinions, preparing for their testimonies. And it always hit me, why do we not have it in India? We do submit economist reports, we do work with lawyers a lot closely, but we've not been able to independently appear before the commission and clearly state what our thoughts are. And I think this amendment is really capable of changing the landscape of how economic analysis and economists are included in competition matters. Because what I expect is that there will be a lot of focus on quality of economic analysis rather than just going to economists for market share analysis. You will see economists from both sides appear. You will see economists working and discussing various aspects of competition case with the commission. I'm expecting a lot of engagement with the commission's questions, which are asked by the opposing expert, by the commission, which the economists themselves answer. So a lot of like the hot tubbing that we see in arbitration matters is likely with competition, and I think that will be very interesting. I also feel the amendment is taking the competition law and ensuring that it is in line with the way markets and industries are working today. If you think about deal value threshold, in merger control, we were looking at assets and turnovers to decide if a company is large enough that their combination affects competition in the market or not. But today, markets are changing. You might have large companies who don't have significant assets or turnovers, but who are capable of actually competing aggressively in the future with an incumbent player. And that acquisition might affect how competition is going to be 10 years, 5 years down the line. And deal value threshold actually addresses that because it recognizes that when a company, say an incumbent, is acquiring a new entrant who has the potential to even beat it in its own market, the value that that company is recognizing is to some extent covered in the value that they are willing to pay for that company. And thus, deal value becomes very relevant. Of course, there are nuances to this that still need to be worked out, like what is significant operation in India, what will the CCI do when there will be multiple cases that end up being filed. But that's definitely something that I'm very interested in, especially in the digital markets. There will be a lot of scope for economic analysis to figure out what would be the actual theory of harm because of a combination happening. Another aspect of the amendment that I'm very, very excited about is there seems to be a lot of focus on effects, which a few years down the line, we were like, is CCI forgetting to look at effects? Is there a turn that we're seeing? But with the NCLAT order on Google, and then even the draft regulations for settlement and commitments, when I looked through those, what I saw was that yeah, you can settle, you can make a commitment, but it's not going to be that, oh yeah, let's just settle at this. It's going to be based on the nature, the gravity, and the impact that your conduct has had, and then how are you proposing to address this effectively? So there will be a lot of economic analysis which will be involved there as well to identify the theory of harm because of whatever is the case be identified in the prima facie order, in the DG investigation. What do you think is the harm and how will you address it in the right manner? So there's a lot of effects-based analysis that is going to hopefully come out in the coming years with these amendments.
Thanks, Jinsi. Now to Rajshekhar. Rajshekhar, do share your views on the amendment, in particular how agents have been defined to include legal counsels, legal advisors.
Thank you, Anand. Good morning. I'm used to appearing before a small bench. I have not even been before a consti bench, so this is a really, really large bench to start off on a Saturday morning. And thank you for taking the time to come here. So as usual, I'm the outlier in the room. Anand keeps describing me as a competition lawyer. I keep telling myself I'm a litigator, and I describe myself as a serial litigator. I look at this entire framework very differently. And I ask myself two questions, because ultimately I'm the one standing there in the room trying to either defend or prosecute. The object of the statute, and of course now the recent amendment, is to make the statute more workable. And the principle is really the theory of harm and the state's interest in preserving a certain state of affairs. My difficulty is the disconnect between what is in the statute and how it is implemented. And frankly, the way I see it, if the statute were worked in the manner in which it was originally crafted, a lot of these amendments were actually redundant. And that, as a practitioner, is something that I'm constantly grappling with, because when I get into a room and I look at the bare text of the provision, and I ask myself, is there enough play in the joints for a regulator to kind of modulate approach and conduct? The answer is yes. The difficulty is when the regulator itself is inconsistent, and I get different messages every time I stand up, depending upon the facts of each case, which are in the broad sense identical, right? Everybody, so either we're all in a cartel or we've abused dominant positions. And that's where I think the disconnect is. Having said that, yes, I mean, was it time to take a stab at having a relook at the statute? The answer is perhaps yes. I would have perhaps wanted to wait for it for another 5 years before we did that, and for two good reasons. We've got a reasonably good body of law that's come out of the NCLAT. My problem with that, again, is you disbanded the COMPAT, which was a specialist regulator, which was actually, which had started doing some fantastic work. And according to me, it was fantastic for two reasons. You actually got hearings, your matters got decided timely. Number two, it was the same body that was deciding the same issues arising out of different contexts, and therefore they got different perspectives. So from that perspective, you get a certain sense of certainty, and since we are a precedence-based country, it would have actually helped industry modulate conduct and behavior. And I think we all work on the premise that, the industry largely is in the market with intent to comply. And of course, these things are aberrations in the true sense, and those who are errant anyway will be found out, if not today, tomorrow. So that's part one. It's in that context that I think I'll touch upon what Anand said with regard to in-house counsel. I think that as a lawyer, it's a no-brainer in that sense. You go in-house, you give up your privileges as a litigator, as an independent counsel. And to that extent, perhaps that's the way the cookie crumbles. So I don't see a problem in that sense. And companies have to start working around it. Yes, there is a disconnect between what the Competition Act says and perhaps the Companies Act, and there are some carve-outs in other statutes. There again, we have a problem with consistency. So my difficulty as a litigator, and this is something, and unfortunately that's the problem with the level of discourse that goes into creating statutes. We have statutes where amendments, in fact, alter words in provision A and leave the erstwhile provision, unamended. So the same expression has three variations in the same statute. So that's that. But on a more fundamental level, I think the idea of introducing the settlements regime is fantastic. But I'm asking myself, if I don't have clarity on confidentiality, and I know that is going to be used against me, and I'm getting a 15% penalty, haircut, would I even want to offer it up, especially when I don't know how the Competition Commission will react in each case? And it is in that place I thought that, and it seems that CCI is in fact making that effort, there has to be a bigger dialogue. So I think the one thing that the CCI prides itself on is it's not a court. Because it is not a court, it is not trapped in by the rigors of that distance between court and council. And it is important for both sides to keep talking and for the CCI to constantly send out messages. We have now the ability to prescribe guidelines and guidances. I have the same issue with regard to pre-consultations. Why can't we have binding consultations? And why can't the CCI? So I think the settlements regime is really in aid of that. And there I think Jinsi has a really valid point. Soon, please take it from me, most of us who are general litigators who are also competition lawyers are going to become redundant, because I think the devil is in the details, and the discourse is going to get into a level of economic analysis and evidence-based outcomes, which really makes, which is really what the statute intended. And at least I'm very positive that it is going to work as far as industry is concerned. I'm hoping the CCI is able to step up its game, because that's where I think there is a huge disconnect. They try their best, their resources are limited, and I don't know if they have the bandwidth to keep pace with the way the world is moving. But like I said, always look at it positively. I think we'll all find a way to kind of push that forward. The amendments, according to me, are the starting point to trigger that new conversation and to make sure that it actually works on the ground.
Thanks, Raj. Purnima?
Yeah, may I just step in on the point on in-house counsels?
Sure.
So the CCI does have a right to seek information from legal advisors, bankers, investment bankers. Raj is a litigator. Whatever he discusses with his client is subject to attorney-client privilege. By virtue of being I used to be enrolled at the bar and I had to suspend it. The issue is not with what the amendment is saying. It's a far bigger issue that in-house counsels do not have attorney-client privilege. I don't expect the CCI to resolve that, but it's a different issue that must be addressed.
Kala, I'm going to come to you because it's a little disconcerting for this Amendment Act to characterize legal advisors as agents who can be subjected to questioning by the DG. What's the status in Singapore, and how would the Singapore lawyers have dealt with this issue? Because I worry. I mean, as soon as I go and I'm subjected to questioning by the DG, I'm in a position of conflict with my client. Forget attorney-client privilege. I mean, I can no longer represent the client if this is what's going to happen. How would Singapore deal with it?
So Singapore is, just speaking immediately on that one, Singapore is very unique. We have legal privilege, not just for outside counsel, but we also have legal privilege for in-house counsel. So, sometimes outside counsel may feel like, you're taking away my job. But the reality is, if you look at it from a bigger picture, right, it's a question of how business should function. And if you want business to function within the boundaries of laws that have been set, doing the right thing at the end of the day, then giving in-house counsel legal privilege, I think, goes a long way, because they become truly trusted advisors. They become the first port of call internally when a business wants to go down path A or path B or path C, and you have those discussions. But if you take away that and you make the legal counsel just like any other business person within the company, I think, with due respect, that's the wrong path to have gone down. And all the more if with external counsel, if you start removing that, then as Anand points out quite rightly, it is clearly a conflict. Because when I act for party A, party A's interest is what I'm going to protect. And our local professional conduct rules make it very clear that I should not be influenced by any other interest, personal or otherwise. I should only be motivated by my party's interest, my client's interests. Hence the risk, whether in-house or external, the risk of being called up and questioned. Save for in the case of clear crime, fraud, money laundering, terrorism, perhaps exceptions are possible, but not in a commercial law like competition law. I think it's going too far. And if Anand, if I can take a liberty and comment on a couple of things. Just to add a couple of other comments on other issues. Settlement, for example, settlement and commitments. I think that's a brilliant thing to have been introduced. The issue, of course, is, devil is in the details, right? And how you implement that. But why I say it's brilliant is, again, using first Singapore as an example. In the early days, we didn't have settlements formally introduced by the law. But some of us managed to push it through. And I know in one of the largest, to date, still largest investigation in relation to dominant conduct, an abuse of dominance in Singapore, and client name will not be mentioned, although it's all public, is the fact that despite not having the laws, we managed to negotiate with the Competition Commission and reach a settlement. The settlement involved giving various commitments. It went on for, in that case, 5 years. It's a lengthy period, but still commitments were reasonable. The commitments were made public so that, for what it's worth, the commission gets its dues as well, that, hey, I investigated this huge MNC and we managed to elicit this from them. But the more important point out of that story is, with competition law, what is it that we want? It's change of behavior. It is making sure the company behaves in a mature manner, in a manner that treats consumers fairly, in a manner that allows competition to thrive. And that's not contradicting the fact that, in business, I want to do well. I do well, but I do well alongside making sure my fellow businesses are also moving forward. And to that extent, I think commitments, settlement process commitments are very helpful. Now, in Singapore, the law was modified. It became part of the legislation. It meant that certain amount of that had to be made public. There was a suggestion that I needed to admit to the conduct, not to liability. But it's a fine line, right? If I admit to conduct, is it potentially liability as well? It's a very fine line. But anyways, the rules are now there. Do we still continue to use it? The answer is yes. And for what it's worth, in Singapore, in relation to abuse of dominance cases, there's only been one which has gone on for hearing. All of the other cases have all been settled, change of behavior introduced. If I just push the point a little bit, Indonesia, which has had competition law for the longest in my part of the world, also has now introduced a concept of settlement and commitments, but they call it a change of behavior compliance program. The laws have just come into force a year ago, so it's kind of still iffy, and we're working for one MNC to try and push some of these things through. And it really calls for a process to be put in place where I show that I'm going to change my behavior through various commitments. In addition, I put in place a compliance program. Is it a good thing? I say yes, because again, we're working with a huge multinational with presence in Indonesia, and we're looking to see how we try and settle the process. And some of the commitments we put in is really to, at the end of the day, elevate the industry as a whole. So that's what competition is supposed to do, and that's what commitments are supposed to do. But when you have the point that Purnima made, where submissions have to be made public, that worries me. Because when I'm making submissions, I might have to share various business secrets. Otherwise, the point doesn't go across. And that would put me in the defensive and say, I want to commit, but sorry, I can't tell you all of this to the commission. And it makes it very difficult. That's going to be a problem. So I think if we want to have settlements and commitments, submissions should not be made public, but perhaps the alternative is what happens in many countries, not Singapore, not just Singapore, Indonesia, and the other regional ones, but also in the EC or UK is the proposed commitments are put out for public consultation so that competing businesses, consumers, supply chain upwards and downwards can review it and say, yes, this is fair, or no, this is not going to go far enough, we need this and this and this. Maybe that, yes, but the submissions itself, I think, shouldn't. Let me pause there. I have other views, but let me pause there.
Thanks, Kala. That was very helpful. I think we're going to increasingly look to Singapore for some guidance in this area. But Jinsi, you're not getting off the hook. I'm coming right back to you. Are you excited about the widening of Section 3.4?
Yeah, of course it is.
More business to you?
Absolutely. More the merrier. But again, it's as I said, it's a way to keep up with the way businesses are thinking about and working in the market, right? You can't have a regulation which is so narrow that it was looking at how businesses used to cartelize or how businesses used to have agreements few years ago. Businesses adapt themselves, and so regulation has to adapt itself, and economic analysis has to adapt itself as well. So I think it's very pertinent, even the requirement that the commission have experts in technology sector today, right? That's also keeping up with the times, because you can't have a regulator investigating and deciding on a lot of the digital market cases, because there are nuances to the market which somebody from outside might not understand. What is the role of, say, machine learning? Why is it important or not important? Where does it cross the line? And then not just the investigation bit, but once you've investigated, once you've decided, but you can't issue directions without understanding technology and how it works. You could come out with directions that do this, but don't do this. But that might not be technically and business friendly at all. So I think that's why I think that it's just keeping up with the times, because if you don't keep it up with the times, if you don't put the wordings, even if it's just a change in one word, but then lawyers like you will go and say that, oh, but the act does not say this. So that's why it's sometimes important to make the changes that have been made.
Raj, I'm in complete agreement with you on one thing. I think our act had everything in it. We did not need such extensive amendments, and we certainly did not need to go down the path of the DMA. That's a personal opinion. I know there's an old saying by Lord Simon of Blaisdell in George Frank, the textile case, a House of Lords decision in 1975, where he said law is too serious a matter to be left exclusively to judges. That was a point of view of the House of Lords in a minority opinion of Lord Blaisdell. But ultimately, in competition law, I do believe that there has to be a vigorous analysis of the facts. And from the facts will emerge the law. There was a continental law judge, perhaps the most brilliant person who has ever adorned the court in Luxembourg as a competition judge, Judge René Joliet. He was a civil law country judge, came from Belgium, but had gone to the US and apparently got corrupted by common law. But he came back, and his principle was, and I say it because I do believe in it, le droit émerge des faits. The law emerges from the facts. If you rigorously and go through the facts, automatically the solution will come to you. You don't necessarily need all these other gimmicks for that. And God bless his soul, his introduction of the rule of reason into Article 85.1 with pronuptia, his dealing with the wood pulp case and many other cases on fidelity rebates, etc., has finally found its way across all the common law countries as well. I come back to you. How do you think we should be dealing with our cases as we go on appeal to the NCLAT and then to the Supreme Court? I do realize that as of today, the Supreme Court has not really decided any major competition law case. DLF is pending with 630 odd crores having been paid as a penalty. MCX is pending. A lot of these cases are pending. So the real guidance hasn't yet come out. We are still relying on practice. So I turn back to you.
No, thank you, Anand. And that's the point I was making. I mean, I feel that there's a lost opportunity here. Unfortunately, that's also the problem with the system. We started by setting out a specialized tribunal which would have developed a body of work, which would have gone perhaps up the ladder. We get side-allied into rich challenges before the High Court, but that's again the way the system is. But it was, and the few times that the Honorable Supreme Court has managed to kind of make a point or two, we have this legislation which kind of, in a sense, seeks to overrun it. And that cat and mouse game has to stop, because at the end of the day, we are looking at an economic legislation. We are selling ourselves as a country which is now going to be at the forefront, of the world, and we want to inculcate this come and do business in India. But I can't get a hearing in the NCLAT 4 years down the line. And when I do get a hearing, I get an order where there are obvious errors in the CCI's order, where in the first instance, the CCI is unwilling to accept that there are errors. And these are mathematical errors. There are errors in terms of fundamental fact, which have a bearing on outcome. And it takes a series of marathon hearings for somebody to finally turn around and say, all right, we'll give you a concession on that aspect. Which is why I said, it is ultimately, no matter how many rules you make, no matter how many statutes you rewrite, unless the people who are tasked with that responsibility understand it and are in a sense, are looking at it as partners. You're the enforcer, but at the end of the day, your duty is really what emanates from the preamble and which is then cast in stone in Section 18. Your duty is to ensure that the principal objects underlying the Act, which is an economic legislation, are met. It's in that context, even for instance, in the context of cartels, I would have liked to see a threshold. It's great to use words like AEC, but if you're telling yourself you're going to be a $5 trillion economy, is an arrangement between people which at the end of the day results in a couple of 100 crores going here or there, really the subject matter of a competition law legislation? I'm asking myself that question. And should you not be picking up the big fish and setting out principles there? And we've done enough in our law between the last 7-8 years. In 2015-16, we've revamped our civil legislation. We've tried to kind of make sure that our civil courts work. There is that gap that one really needs to fill. I think it's important for the Supreme Court to now start considering, since you started designating people on the basis of their expertise, to start getting benches which start hearing matters, which are arising out of specialized tribunals, and doing that. We've had some phenomenal success with our IPD, for instance, in the Delhi High Court. You see a body of work in the intellectual property space, which is phenomenal today, only because you have a series of dedicated judges and dedicated counsel who are doing this day in, day out. And somewhere along the way, that discourse really, kind of gets elevated. The Supreme Court is clearly missing a point, and I think it's important for everybody who's in the field to request the Supreme Court to just identify. There are at least 20 or 25 important competition law issues which are actually hanging fire in the Supreme Court today. And the problem is the judgments that have emanated from the NCLAT address issues on facts, but ultimately don't really give us substantive guidance, barring the odd exception. And that is where we are. We are like I said, a precedent-based, jurisdiction. And it's important for us to not miss that point. Having said that, it's also important to look at the body of scholarship that we have in India on competition law. How many books do we have which are actually, fleshing out issues that matter? And we are still borrowing from the West. So we've got the principles from there. Our experience, our requirements are really, really different as things stand. We are at least, a few decades behind in terms of the way we are, and we want to be 3 decades ahead. So it's that disconnect that I see. It's something that bothers me every day. And like I said, I argue on both sides of the spectrum. So, and when you look at it academically, you try and look at it from both sides. Net. Is this one of those conversations where one of the judges of the Delhi High Court walks back and says, I also heard a snippet on this aspect and maybe we should do that? But it's important for us as a country to start looking at specialization, not only at the practitioner's level, but also at the institutional level. So we are doing half-baked measures. That measure has to go the whole hog. I think that's really where I see it. And I'm hopeful that the experience of the IPDs is going to take us to some of these. Tax, for instance, we had the same issue, but our tax tribunals are stuck, our high courts are stuck. We don't have enough enough judicial precedent coming out there. So somewhere along the way, like I said, we are all a country of generalists, which is why you have a generalist sitting on a competition law panel. But having said that, we all pick up our ropes along the way. Here you are.
Yes, please.
I just want to make a very quick comment in relation to what Rajashekar said in terms of expertise. I think that's absolutely critical. So, I feel very tiny coming from a country with 5.5 million people, but only really 3.2 million Singaporeans. But yet, let me share the example. One of the key problems we had with our competition commission is typical civil service style. They used to keep changing every 2 or 3 years. They'll rotate because the legal service for the legal guys, they will move from one ministry to another ministry, one statutory board to another, and people just kept changing. And we were like, what? We got to re-educate again now? I mean, when it was first introduced, we all learned together. And then they switched, and it became a bit of a pain. Our approach was even more critical because we only went to the CCCS, and then from there to an appeal board. We only go to the court if it's judicial review. So it's really limited. But I think members of the bar made enough noise that what they did was to have 2 tracks. So they still have the rotation with the civil legal service, but they had permanent staff come on. So now 18 years down, I have the chief economist who's moving on to the digital division that they're starting, but he's been there for like 10 or 12 years and he's just brilliant. Our original CEO was there for more than 10 years, and so on and so forth. The experts have stayed. And it reflects in the discussions you have with them and so on. And that's something that was true of the judiciary as well. Not talking about competition law, but over the years, in the last 20 years, they saw the importance of having experts in the right area. So for those of you who were in the room in the earlier panel, Justice Quentin, for instance, he was brought onto the bench because of his expertise in construction and insurance law. We do that with different individuals. Now, it's not just Singapore, but Malaysia, if they can get their act together. But it is another thing which is being argued, where expertise is necessary, not because generalists don't know, but there are nuances you pick up because you do work in that area. I would never dare say I'm a construction lawyer because I don't know what I don't know. I would never dare say I'm a criminal lawyer because unconscious ignorance. So for that reason, I think if we get the right expertise in, and I say this to a lot of people, and again, pardon me coming from a tiny little country, but India is largest population in the world now, or still second? Largest now, with the aim of becoming the 3rd largest world economy. It is so possible. It's just incredible if that happens. But it's getting the right expertise in the right place. And a lot of things have happened in the last 12, 15 years, and we from the outside can see that. We see huge differences. Yeah. Something as simple as completely out of competition law, something as simple as, when you watch movies coming out of the UK or coming out of the US, it used to be, pardon the foreigners in the room, but it used to be all Caucasians. Then you had the original Latinos, then you had the nominal Chinese, but now you have the phenomenal Indians in Western movies. So it shows that the Indians can do a lot more. And I'm just saying this as a tiny little Singaporean.
Thanks, Kala. Well, competition law has affected Bollywood as well. I've got to add that. But you said something about your chief economist moving to the digital markets segment. I hope that's not a hint that there's a Digital Markets Act on its way there.
I hope not to, because I really, really think the principle-based approach works. I don't think we should have the Digital Markets Act in the way that the UK has. Yet there's something to be said about the digital world. It is unique, it is different, it evolves very quickly. When you talk about market definition, what is it? What's the market? And, you know, I've dealt with very traditional markets like beverages and water. Is it in a market of its own? To going to big data, and is big data a market on its own, or do I need to look at the company specifically? So market definitions vary. And Jinsy mentioned about markets just now as well, in relation to transaction value when you're looking at mergers. So the point is there's a lot of complexity in all of this. With the digital world, innovation is happening very quickly. And it's not just a case of turnover makes me a lot bigger and more powerful in the market. It's not automatic. I need to study it a little bit more. So Singapore, very much like the UK, although UK is looking at legislation, decided to set up a unit to look at digital-related type issues. I think that's important, but it doesn't mean we go and start prescribing rules specifically for that area. That would be, in my view, for now, a no-no.
Thanks, Kala. Purnima, I'm going to come to you. We're running out of time, but I'm going to come to you for the final word. You're in industry, and you're with the Tatas. I'm not going to hold anything against you as to what you say. But what will be the impact of the deal value threshold on investor sentiments? You do have PE investments coming in. What do you think is going to happen with this deal value threshold coming in?
So the deal value threshold the concept has been introduced. It's set at 2,000 crores, which means the CCI's approval would be required for any transaction where the combined value is above 2,000 crores, and two, I believe it's substantial business interest in India. I think we are just at a macroeconomic level. India continues to be at a phase where investments are important. It's critical. It's critical for AI, for data, for digital platforms, cloud, cloud and related data centers. I think the impact will be that PE players will restructure their transactions and come up with structures to avoid the CCI network, so to speak. I'm not sure how. The fact, one is an objective test, 2,000 crores. Substantial business interest, nobody knows really what it is. Substantial, material, significant. I think people like Raj can argue endlessly about what it is, but because there's a subjective element, people will likely use that and come up with arguments, come up with a strong defense to take transactions out of the purview. Is it a dampener? Probably.
See, that's what I worry about, because already there are too many dampeners to PE investments. The depreciating rupee, you invest at 75, at an exit, you're 85. You've already lost part of the game. So, yeah, I worry about that. But you're right. Raj can put a spin on stuff that is incredible. I prepared agreements, and I go into an arbitration or a court or in competition in the CCI, and then the litigator comes in. And I turned around to the litigator. I never meant that. Well, he said, now you shut up, let me take over. He introduces a new topic. But thanks very much. That's very helpful. I open it to the audience if you have any questions. Shashank, go ahead.
So one question to you, has asked about that. And it is more from your statement in the previous competition law panel, and also one statement today. The previous statement was that you, I won't say sort of appreciated CCI's decision in Google, but you said that you have taken a position. And on the Friday panel, when you said you have taken a position and you have given a decision. And the second statement this morning, when you said that don't mean what I am saying, I am asking to provoke. So coming from there, what is wrong in this, if this country, though they like to have foreign capital, they would love to have technology to serve billions of people. Leaders of this country would like to have photo op with GAFAM, but also regulate them differently. When you make your Digital Market Act, you will only focus on those 5 American companies, not just here, even in Europe. So what is wrong in that? You have taken a position that for my own people, despite all other factors, I want to take a position to regulate it in that manner. That is my first question. And second question is to both you and Raj sir, is on the issue of global turnover. Somewhere it is already there in the Tata Motors case, when Tata Motors was, sort of both Jaguar Land Rover numbers were also taken in. What will happen to these companies in India who have very different business model from what they do in outside India because of the FDI regulation and all? But when it comes to imposing penalty, it will still be global turnover. So how will that nexus be established, and whether that nexus can be challenged? And as a starting point itself, it will be a docket explosion for Raj sir and the law firm saying that, okay, let us go challenge that itself. So these are my 2 questions. Thank you.
Okay, take the first question first. When I said that CCI has taken a position in the Google case, the point I was trying to make, and we don't go into the merits of it, although I think it's a good decision. But the point I was trying to make is that based on all of the existing laws, CCI was able to take on a giant and come up with a position. Lawyers, we will always argue it's wrong if we are defending, right? So we're going to always say CCI is wrong. And even if I'm coming from another country, if it's the same crime, I'm going to say, oh, that regulator got it wrong. This is how it should be. But the point is the CCI was able to do it without the laws being amended. And that's amazing. That's amazing. My statement today about provoking, it's not about CCI. It's just putting a whole range of things out there and trying to see what different views could come forth. Because again, as a lawyer, I used to joke, I could argue this is black ink on white paper or white ink on black paper. It's become a lot harder now with technology. But that's what many of us do as lawyers, right? So it's a question of, without falling foul, within the boundaries of the law, it's how you make the arguments, and hence the provocation. And it's a topic we can talk about a lot more. In terms of turnover, very quickly, I think we got to be careful when we look at turnovers, and I will be honest, I haven't gone to read the Competition Amendment Act language very carefully, but if you look at across the world, how turnovers are considered, be it for a penalty infringement and how you impose, or be it for a merger and whether you should notify, there are slight differences. And if you take the merger level, again, from country to country, it varies. Some of it will just take total turnover. I don't care what business, I will look upstream, whichever entity has control, I want the turnover of all of that, although the merging party is somewhere in the middle. And I just take total number. It's just an easy way for many countries to look at turnover. But they have a second threshold, like China, for example, and various other countries, where they also look at turnover within the country. But apart from that, they will have alternatives. So transaction value, which is, I understand, coming into India, is something that is looked at. Transaction value can be looked at globally, or transaction value within that country. So Philippines, for example, will look at transaction value into the country. There's merit in that, but in the digital world, should I just be looking at transaction value into the country? And maybe I need to look at it globally. And there's a lot of different issues that come up. There's also market share, which Singapore is unique. I won't go there for now. But if I take turnover and apply it to penalties, I don't think we should be taking turnover at a global level blindly and saying, like the EC, if I just look at the rules blindly, 10% of global turnover, which Malaysia has adopted, 10% of global turnover. Rather, it should be relevant turnover. So here then I need to ascertain where's that violation, and then have it takes time, but ascertain what the turnover in that relevant market is, which means that if I go with, let's take aviation. I am just picking up something blindly. Singapore Airlines. Singapore Airlines global turnover worldwide will be huge. But if I say I'm going to look at a violation, not that there is any, but say between Singapore and London. So I look at origin, destination, and I say that's the relevant market, origin, destination. So my turnover is going to be focused on that, and I will ignore Singapore Airlines turnover everywhere else, because it doesn't matter for the penalty perspective, because the harm is potentially for Singaporeans buying tickets to fly or for UK buying tickets to come back. It's limited. So I think even with turnover, we got to there's no generalization. We got to look at the purpose and what are we trying to aim at.
No, quickly, I think Kala's hit it spot on. And I think it ties back to the point that Anand was making. It ultimately relies on facts. So if the facts demonstrate that the money is really going somewhere and the business as a whole is, in a sense, profiting from it, then why not? But the Supreme Court clarified that. And I guess the only reason we've got global turnover today is to perhaps give the Competition Committee the jurisdictional ability to look beyond. Will the Competition Commission use that as a blind marker and start imposing penalties on the basis of global turnover? I hope not, and I believe not. But is it possible? The answer is yes. Is there guidance in the law? The answer is also yes. And it will necessarily have to be relevant turnover. I think the rule is this: in the process of trying to bell the cat, don't hang it.
Yeah.
You know, and that's really it.
Sorry, you had a question.
So one, of course, the comment that I wanted to make, and that is from Mr. Rashikar Rao's point that he made that, we need experts
If
in
you
the...
can tell us which firm, etc.
I'm Shweta Bharti. I'm a senior partner at Hammurabi and Solomon Partners. Now, the question the comment first is that, taking the cue from what he mentioned, I think there is a need for us to move away from tribunalization of justice to where we were actually there in terms of High Court having an IP division and doing so well. So probably if we are able to take these competition matters at the appellate stage before High Court, probably would have make more sense with specialists sitting there to decide. And maybe Supreme Court also needs those kind of, economists to be able to assist. Why Supreme Court is not coming up with judgments is also because they do not have that kind of an expertise, and they are waiting for some expertise to be brought in there. And because legal issues are separate, but about competition law, so economic issues are also relevant. So that was the comment to make, and probably some of these discussions should go up to the law minister as well, probably for his understanding, because a lot of relevant discussions are being made here. The question is, there is an introduction of the term called hub and spoke. Now I wanted to understand this term hub and spoke that has been introduced. Going to make, in difference in terms of utilization, because it's about the intention. The intention, how are they going to prove that there was an intention in the first place? And what is this concept which has been brought in? And any of you who would want to explain this a little?
There are so many structures, so many different forms of doing business. They're all already covered. The CCI need not look far. It just needs to open the statute and look at it. I'm worried the day when a genuine joint venture comes before the commission as to what they will do. I'm worried more about the day when a chain of joint ventures comes before the commission with one common parent in each of these joint ventures. There is an EU case, Dow Corning. So the issue is, it's all there already. They needn't have added this in here. Thanks very much, everybody, for being so sporting on a Saturday morning. And thank you, everybody here, for this honor. Thank you.
Thank you. Thank you very much indeed, Mr. Pathak. And thank you to all of our panelists. I think we had a phenomenal time enjoying the session and so much to learn, so much of interesting conversations that's taken place.